clerk says. We're missing one person. I think we ought to wait.
I think we
Okay.
I'm sorry. I will. Okay. We'll get this chair out of the way. That was our plan. I'm sitting.
Wait for it to come.
Here we go.
Very good. Madam Clerk?
Case number 13-8320, the People versus Robert Bashara.
Appearances for the record.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
Good morning, Your Honor. May I please the court? Robert Moran, Assistant Prosecutor.
Good morning, Your Honor. Patrick Muscat on behalf of the people.
Mark Hindling on behalf of the people.
Judge, good morning to you and your staff. Lillian Diallo on behalf of Robert Bashara, who's present to my left. Good morning, everybody.
Good morning, Your Honor. Michael McCarthy appearing on behalf of Mr. Bashara.
Very good. Everyone may be seated.
Thank you.
I just want to say at the onset of this particular case, Mr. McCarthy, that this has been a very long and a very emotional trial. And there may be things that may be said by each party that one may not agree with. Please, no outbursts, no snickering, I'm sorry. Nothing that would divert attention from these men and women who have been taken from their jobs and their homes to be able to listen to this evidence. If you feel that there is something that you cannot accept, if there's something that you feel that you do not agree with or that you don't like, just please kindly remove yourself from the phone. At this time, let's bring out the jury. Oh, wait a minute. I'm sorry. Is there anything we need to put on the record outside the presence of the jury?
There's one thing, last night when I was going over the instructions again, I did notice one thing with the instructions. I emailed the change to defense counsel, and I'm sure we'll take care of it before the instructions.
Just one.
Yeah, yes, just one. That's my
Sure.
understanding.
That's one I caught. I don't know what anybody else did, but
Mr. McCarthy?
I agree with Ms. Lindsay on the one minor thing, and I believe that can be corrected very quickly and easily. And I don't think that there's anything else that needs to be attended to.
Are you sure?
Yes, because I must say that I follow Ms. Lindsay's lead on these things many times, and she's very detail-oriented, and we have traded back and forth throughout the whole course of this trial. I was confident that everything was right when we left yesterday. There was one minor thing that she caught afterwards. I saw that at about 5 o'clock yesterday afternoon. I said, yes, she's correct, and I believe that that's it. I think everything else is in absolute proper order.
Okay, very good.
I try to catch everything, Judge.
Okay.
As do we.
Okay. Because if we don't catch it by tomorrow, we don't want the Court of Appeals to catch it.
I know that's right, Judge.
Very good. Okay, great.
Let's go.
Bring that jury in.
Judge,
All
can we
right.
just get, can we
All
get,
right.
Wait a minute.
let's get, can we get in place first?
Okay, let me do this. Let me take a 10-minute recess to get me together.
Sure.
And then you get together.
Okay.
And then we're rolling.
I don't know, Judge. I'm just saying, once they do their argument, will we have a time to break so that we can switch over?
I got this.
I know. I just want to know, Judge.
Let me be the judge.
I don't want to be one, Judge.
Okay.
I just
All
want to be a
right.
person.
Mm-hmm.
I
very
don't.
good. Give me 10 minutes.
Okay.
Well, I already know how procedurally we will do this. This will take all day. So we will not be doing any instructions today. We'll be doing them tomorrow.
Yes.
So I know how I'm going to break with them. And let me do my job, and I'm going to let you do your job. All right?
That's fine, Judge.
Thank you. I'll be back in 10 minutes.
Thank you so
Let
much.
me know if you need anything.
Thank you so much. 10 minutes, okay. So how many hours? I mean, we're going to have to. You know I'm worried. I'm a worrier. I worry for a living. That's what I do.
In the projector.
Wait a minute.
Lacey,
Good luck.
We can move it.
Yes.
Yeah, actually. I put my notes there so I can see. Sorry. You could push if you want. Put it in front of the one thing and then just have to bring it back. Because it's kind of a hassle. Because I like to set my notes on it.
I'm gonna go to the lounge, the attorney lounge. So you go ahead and head over there. Here I come. 10 minutes? Okay.
You never know. That's yours.
Oh, I know what you're talking about. She has a hat on, and she was listening. Yeah. Oh, she can see between.
I'm sure that's what he's gonna be doing. Something scientific.
this was number 35.
Maybe one right there. Like some art.
Okay, thank you.
Oh, okay.
All right.
No, I don't know.
Yeah, I was like, I was getting to but I did, you know, because they have the same.
A few of them are on. Yeah. Yeah, what? No, that's weird.
I sat in the box. I was done with it. Like a half an hour before somebody, she's the one, the lawyers didn't know.
Shouldn't know you were?
I'll do summary A, she'll do summary B, and I'll do the end. You know, and it kind of follows the witnesses.
Okay, all right.
You know, I mean, it's just, not 100% like that, but in a big way.
Okay.
So,
Okay.
I think it is because the original division of labor she did. Actually, you know, when it was just you got one last right.
Yeah. Exactly.
So the closer we got,
Don't worry.
yeah.
I'm sure we'll do it tomorrow. No break. Yours take a break.
Exactly.
I would want you to go and think through your stuff, but
So,
With that in mind, by the time it gets to time for rebuttal, you probably need another shave.
exactly. Right, that's what I was thinking. Yeah.
It's all different than the usual seat of the pants by comparison
Yeah,
closing
right.
you put together.
Well, you know, our rebuttals are usually seat of the pants kind of thing. That's, you know, I like doing that way. You know, think about, anticipate some arguments and think about some responses, but most of it is just whatever the theme is you guys
Yeah.
develop and pick up on that and go from there. You know, so I don't have a lot prepared. Just kind of wing it, as I say. So.
You know, if ever you knew something.
Exactly. Exactly. Yeah, an idea or two.
That's right.
Yep. Pat gave me his fancy pointer, the green one. We had a very good movement. Come on.
Wind in all right. Everything here.
That worked for me. But it is, but
Who, me? Well, yeah, it needs to be in the line. You're gonna need to do some writing too, aren't you? Okay. Oh, no, I don't want to give you my, Mike, you got a
Right
yellow?
next to Lily.
Good. You got a yellow legal pad? Good. Here, so you know what on that, because I'm gonna have him do some writing. You can do it. And I can't let go. I was listening to the Isley Brothers this morning. The Isley Brothers. I was listening to them. Hello. She's gonna take my DVD. I'm like, no, use my feet. And let me know. Okay, we got enough stuff. But they were down here. They took them. No, they used. They stole them. Using if you bring it back. Yes. I'm like, that's okay. That's okay. We got enough stuff. Well, yeah. Don't worry. Yeah, well, I gotta stay.
Don't have it.
Good. Yes, I do.
Great.
Make sure I have the okay. Yeah. Oh no, I'm gonna. Somebody just. Oh yeah, we're good though. Right? No, I know. I know what I'm saying. We aren't saying anything. Okay.
No.
I know what you're saying.
Just so you know.
Yeah, I know. I got you. I got you. Where's the microphone? Thanks. Yeah. I think, yeah. You was just using it where my whole
Even
You'll pass them on during that point.
Okay. 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 I'm writing it down, so just in case.
yeah, right. Because I look, you know, I got all these.
Okay.
Most of it.
Yeah.
Yeah, I won't. Once the jury comes in.
No, we're all right.
My wife had.
Oh, were you asking to reach back?
That would be gentlemen. No, no, someone wants. Oh, you're good. You're good. Don't worry.
Oh no, Mike, I was there last night. It was hard to watch.
Oh, yeah.
I don't know. They had nothing. They can't be as simple as 2 zones. Good. It's pretty quick. It's quick. They quick on the ball. Some good shooting too. It's tight. Just straight up 3-2. They were trapping outside the arc. Shut everyone down. We will. I'll figure it out. One of the problems. There's no inside game. Never had an inside game in the last couple of years. Like very in and out. Darren Morris not being that great. The new kid, he's a freshman. And he plays like a freshman. They threw the ball coming out. He missed it. Yeah. They gotta do something with that. I don't know what it is. It's hard to watch. What else there? Yeah, I didn't see it. I think it was the end of the ball. It's early yet.
Oh, I think I took care of that yesterday. Yes, I called up there, I sent a stiff to Germany. I talked to Brad, I told him, Lillian's gonna be sitting
What
right
day
next
does he want?
I put it to the 18th.
Okay, I'll let you.
I know I'm gonna be away.
The 18th?
Trial's been adjourned. I'm
Okay.
gonna go up there. You can't make
Okay.
it, don't worry.
Okay.
I got it.
Thank you.
Whatever it is,
I'll look
that's
at it.
taken care of.
Thank
We know
you.
we're coming next week.
Okay, good.
I got another thing I gotta be with anyway.
Okay. Thank you.
Moved 2 other things 4 weeks down the road just because I didn't want to be stuck in this murder trial. I didn't get the word until this morning that that's adjourned.
Okay.
So, but I'm good. I got it. You just let me know. You can't either. Just
Okay.
call me, tell me what it is I gotta do. Is that guy in or out?
He's out, so I'm gonna let him know.
Let him out. 8:15. Because if I got my bodies there,
I know.
I can make it
God
happen
bless
fast.
him.
They're nice to me.
I know, but he's a special egg. But I'm gonna get him.
You know what? If he doesn't show up, I gotta be there in the afternoon
Okay.
for something else.
Okay, that's
So
fine.
won't worry about it.
Thank you. Because it takes him 3 hours to get there on the bus. I know. He's special.
I understand that. Represent numerous people with that job. But, you know, even then. But I gotta stick there. The guy mentioned your guy's name.
Oh, don't mind. Yeah, I know.
Yeah, okay.
Thank you. Oh, Jesus. Huh? It's
I didn't have some of the protocols.
You know what? I'll just hold up the hard copy.
Yep.
How did she end up? Because she violated the law. Quick remand on there.
I'm sure.
What kind of file? That just happens when you plug in a flash drive. You gotta add.
I don't even understand this. Oh. You get paid.
Ready?
Court is back in session. Remain seated and quiet.
Oh, yeah. Okay.
Madam?
Case number 13-8320, the people versus Robert Bashara.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
May I please call Your Honor Robert Moran, Assistant Prosecutor.
Pat Muscat on behalf of the people. Good morning.
Martin Lang on behalf of the people.
Lillian Diallo on behalf of Robert Bashara.
Morning, Your Honor. Michael McCarthy on behalf of Mr. Bashara.
All right. Please be seated.
Case number 13-8320, people versus Robert Bashara.
Good morning, Your Honor. Lisa Lindsay on behalf of the people of the state of Michigan.
Good morning, Your Honor. May I please support Robert Moran, Assistant Prosecutor.
Good morning.
Good morning, Your Honor. Patrick Muscat on behalf of the people.
Morning, Barb Hindling on behalf of the people.
Good morning to you and your staff. Lillian Diallo on behalf of Bob Bashara. Good morning.
Morning, Your Honor. Michael McCarthy appearing on behalf of Mr. Bashara.
Okay. We never any push break yet, okay? All right, very good. Now, you can be seated. No, you can be seated. We ain't ready to start yet. Just have a seat. Let me explain what's going on here. The evidence is concluded. This is each side's opportunity to address you as to what they believe the evidence shows. You are the final judges of the facts. You determine what the evidence has proven. Because the people bear the burden, they go twice. The court is going to give each side 2 hours to do their closing argument. Followed by rebuttal, the court is going to give 25 minutes for the rebuttal. Because the people bear the burden, they go twice. What the court will do intermittently is to give you stretch breaks as well as breaks in between. We're going to take a lunch break after the people have presented their case. We'll take one for maybe an hour, 15 minutes. I'll determine that. Then we'll come back, but we're going to break it up because it's a lot of information. And you've been here a long time. But remember, this is what they believe the evidence will show. Madam Prosecutor, you may begin.
First off, I want to thank each and every one of you who've been here since the beginning of October. It has been a long trial. I don't think we could have anticipated from the very
Madam?
beginning. I don't think we could have anticipated from the very beginning how long the trial would actually last. This is a very important case. There have been some emotional moments during this case, and there's also been a lot of laughter in this case, and that's good because sometimes when things are sad and tragic, you need the laughter to relieve the tension. This is a sad case. And as for me, I'm thanking you on behalf of Kim Worthy, the prosecutor, but more importantly, I'm thanking you on behalf of Jane Bashara, because unlike anybody else, she doesn't have a voice. In this case, the people of the state of Michigan speak for Jane Bashara, and we speak for the dead. And that brings me to the power of words. Words are powerful. Every criminal conspiracy basically begins with whispered words between the co-conspirators. Words bringing forth an action. There is power in the spoken word. If you don't believe me, just go to Genesis. And God said, "Let there be light," and there was light. He spoke something into existence. The defendant also had the power of words, and he spoke something into existence. The defendant created out of his words a whole another reality for himself. This is a reality different from the reality he had with Jane Bashara. It was a reality different from his financial struggles. It was a reality where he did not feel his wife was overly critical of him. It was a reality he created with his words of a man who was not emasculated, as he explained to Janet Lehman and to Rachel Gillette. His wife made him feel emasculated. With his words, he named himself. He named himself Master Bob, and therein created another world. In this world, as he said to Janet Lehman in one of his emails, "Soon you will feel my strength and passion." That's not the man who has erectile dysfunction. That is a man who feels powerful, work and needed. That was different than the reality he was facing. So he created a life as a BDSM master, Master Bob, and he had a life as Rotary President and with Jane. He created one world, he was living in another, and those two worlds ended up colliding. And when those two worlds collided, Jane Bashara ended up dead. Now,
Nancy, I hate to do this, you gotta keep your
Okay.
voice up as dry.
okay, she ended up dead. Now, the law recognizes the importance of words. And in life, we recognize the importance of words. In the book of Matthew, says, every man will be held accountable for his words, and his words will either justify him or condemn him. That concept is enshrined in the law, because the law does not really divorce itself from divine truths and common sense. And you're going to be getting it, and the law deals with how to treat a defendant when he lies. What evidentiary value can you attribute to a defendant when he lies? And there are several types of lies. There are lies of commission, where you actively tell a lie, and there's a lie of omission, where you leave something out. And the law gives you a certain guideline on how you can view this evidence. The law says that if you find the defendant made a false statement, if he lied about his involvement in this case, that can be considered by you as circumstantial evidence of guilt. That can be considered by you as circumstantial evidence of guilt. And the judge will give you an instruction about evidence. I can prove something both by direct evidence or by circumstantial evidence. And if you look at the defendant, his conduct and through his words and lies, if you find he has lied about certain things in this case, you can use that consciousness of guilt to apply to the elements of this case and find guilt. Now, there are several times that the defendant gave conflicting statements in this case, and his conflicting statements related to his relationship with Joe. The defendant's relationship with Joe is at the heart of the conspiracy. Why is the defendant lying about his relationship? First, he told his daughter, Jessica, that Joe only worked at the Reynolds. Then he said Joe was at Middlesex once to rake leaves, and he met Jane, but he never told her the iced tea story. And then you get these other statements from the defendant concerning whether Jane met Joe.
Did Joe do odd jobs for you at all at any point?
Yes, he did. In the December area, he came to me and said that he lost his SSI, he needed some work, and I provided him some menial jobs, doing some cleaning. There was an apartment that was trashed that we had to clean out. I let him do that. He did a little painting for me. It was just a small amount of work.
Stop there. Never said Joe had been to Middlesex. Just didn't mention it. Next statement.
Did you ever come to your house, Bob?
One time, to do some work in the backyard.
When did he come to your house to do work in the backyard?
1st of January, first week in January.
Did Joe ever meet Jane?
I don't know. Not at that time, no.
When he was doing work in the backyard, was Jane home?
No, it was during the day. She was at work.
At the heart of this conspiracy is the defendant's relationship with Joe. And the defendant is giving these interviews. And when he's giving these interviews, he's saying that Joe never met Jane. Never met Jane. That false statement, if you're based on his conflicting statements, that collectively with other evidence is circumstantial evidence of guilt. He says something else now.
Did Joe ever meet Jane?
I don't know. Not at that time, no.
When he was doing work in the backyard, was Jane home?
No, it was during the day. She was at work.
But in his most recent interview with Dateline, Bashara says the handyman did have a face-to-face encounter with Jane here on Middlesex.
He did some yard work out back. He had met Jane out in the back. And she brought us iced tea one day when we were cleaning up shrubbery and preparing the backyard for the winter.
Well, that's a direct contradiction because in the first story, he says he comes in January, or one story comes in January to do some work out in the back. Now he's talking about shrubbery and giving iced tea. And who's going to bring somebody iced tea outside in the middle of January? Those false statements, the law says, I'm not making this up, this is the law. The law says you can take that as circumstantial evidence of guilt. What else does the defendant say makes false statements about? There's a whole series, and notice how these false statements relate to his relationship with Joe. He never mentioned anything about the phone contact he had with Joseph Gintz on the day that the body was found. The phone records show that there was a phone call that was over a minute between the defendant and Gintz. He never mentions that. On 126, he uses his mother's cell phone to call Gintz, and he had never used his mother's cell phone to contact Gintz ever before. And shortly thereafter, he takes a check to Gintz's job. He gives an envelope to Laura Calloway, and Calloway positively identified the defendant as the person who gave the envelope to her. The check was cashed on the 26th, and the check was for $452. But Mary Morey, who was with the defendant after he got a cell phone, said he had loads of money after that was over. And the timing of the payment to Joseph Gintz is quite suspicious. On the 25th, the defendant finds out his wife is dead. There are people at the house, funeral arrangements to be made, children to be comforted, and then all of a sudden, he decides, I gotta go pay Joe Gintz this $452. There is no way in the world, in the grand scheme of things, that paying Joe Gintz is even on your radar screen after you found out your wife has been killed. But he makes a point of going to pay Joseph Gintz on that day. And furthermore, he makes false statements about that payment. He tells his son, Rob Jr., I paid him before the murder, but he just cashed it after the murder. And he tells his friend Richard Falcinelli that he had a face-to-face encounter with Joseph Gintz where he handed him the envelope, which we know from Mary Morey is not true. Those false statements, in and of themselves alone and collectively, can be taken by you as consciousness of guilt and circumstantial evidence of the defendant's guilt. Now let's look at the letter that he drafted and that he had drafted by an attorney to turn into the police. The timing of the letter. There has been a lot of talk being made about the police focusing on the defendant right away. Well, let's examine why they focused on the defendant. On the 24th and 25th, he talks to Officer Hayes. He tells Officer Hayes no marital problems whatsoever. In the death notification, he talks to Olson, Locke, and Hannes. He tells them no marital problems, but he talks about a disparity in finances. On the 26th, when he goes on and gives his statement to the police, a tape statement, they talk to him at length. He never once mentioned anything about having an affair. He never talked about anything about the BDSM. That's on the 26th. But he does talk about the financial issues. But on the same day, and you will have a calendar with all the exhibit numbers on it, the same day that the defendant goes in and talks to the police, they immediately get tips because the defendant has been on TV about Rachel Gillette. So now we know on the 26th that He's lied about having an affair, and there are marital financial issues. On the 27th, he goes to the police again and gives a statement. Now, the police, when they're talking to him on the 27th, they know already about Rachel Gillette. He never mentions Rachel Gillette. And at that point, Olson privately and Grosse Pointe publicly decided he was a person of interest. Reason and common sense, you would, anybody with reason and common sense based on those facts would give the defendant a closer look. Now, the defendant, and up until this point, the defendant has not mentioned Joseph Gibbs' name at all. None whatsoever. I have no clue what happened. Random carjacking. But once focus is shifted to him, and he knows the focus is shifted to him, he has a letter drafted. The timing of the letter is after he's a suspect, and let's look at the things he doesn't say in the letter. He talks about some phone contact, but he doesn't mention other phone contact. He doesn't mention the phone contact on the 25th. He doesn't mention the 26th, using Nancy's phone. He doesn't mention payment to Gentz. And he doesn't talk about meeting Gentz through Mr. Chavato. Those are all things he kept out and away from the police. Those omissions can be taken by you as consciousness guilt. So now, not only do you have outright lies, you have lies of omission. Those things can be taken as circumstantial evidence of guilt. Now, the defendant made several false statements about where he was or the period of what he did that day. Now, let's look at his first story to the police. He said he was at the Mack property the whole time. In his very first dispatch call, he said he was at the Mack property the whole time. He tells Breen, Debbie Breen, and Miss Flaska he was there the whole time. When he got the death notification, he told Olson and Locke he was there the whole time. He told Jessica, Robert, and Eileen Stradlack that he was there the whole time, and in his official statement, he said he was at the Mack property the whole time. But that story changes. The second story is he had to go back to Middlesex to get keys. And he told that to Jessica, Robert, his cousin Mike Scaff, and to Eileen Stradlack. But there's even a third story that comes from the defendant, and that's the story he told to his friend, Mr. Falcinelli. And it's very interesting that Mr. Falcinelli, before he even gave his first statement to the police, indicated that he contacted the defendant and David Grimm, his attorney, to get instruction for Bob's benefit. And after getting instruction for Bob's benefit, he tells us in the first statement that the defendant said he was traveling between multiple properties that day. And what's even more important about this change in story is the defendant omitted something very important from that story. He never mentioned to the police, his friends and family, he never mentioned to Mr. Falcinelli anything about going to pick up the closing packet for the house on Kensington. Both Ms. Young and Ms. Michelli indicated that about 3:30 on the 24th, the defendant came to the office and picked up the closing packet. He doesn't tell anybody that. That is something he is hiding from the police. You can take that as circumstantial evidence of that. And now let's look at something that the defendant did in terms of misdirecting the police. The defendant claims that he is trying to help the police find out who did something to his wife. He said, I'm cooperative, I want to give them information. And so he talks about, well, maybe his wife went out for some marijuana. Let's hear that.
Hormone pill. Okay, and she was having trouble sleeping was a big challenge for her. And you were talking about getting up there, and I'm not going to narc on my poor wife, but she did smoke marijuana. Okay. Okay. No, but that's good, because you know what? It's gonna come out in the tox screen anyways, if you're doing a blood thing on her, I'm sure you've looked at her. So, she, took a couple puffs before she went to bed, helped her sleep. I saw no trouble in it. I mean, I used to smoke when I was in high school. I haven't touched it in a while, but, I didn't see any trouble in it. Sure. I didn't really know where she was getting it from, but I wasn't gonna question it, and I let her do her thing,
Okay, so that's another angle, which is an important angle, because,
Maybe.
Two things in that clip. He throws out to the police that maybe she got killed when she was out getting drugs. Well, actually, three things. He doesn't know her source, and he says he hasn't touched anything like that in a while. So the first thing is he's misdirecting the police, making himself look better by saying, I don't do that. And then also saying he doesn't know the source, which is a direct lie, because you heard the testimony of Julie Rowe, who indicated that he, the defendant, supplied the marijuana. And then you have the testimony from Mr. Carmody, who was a good friend of his. Mr. Carmody indicated that the defendant said he knew Jane did not go out for marijuana because there was an ample supply of marijuana at the house. That is a direct lie to direct the police away from the defendant. That, by you, can be taken as circumstantial evidence of guilt to be applied to the elements of the case. The defendant talks about the Backpage murders as a way of misdirection.
Her husband is now asking for the public's help.
Please come forward. The police need your help. In addition to those 4 women that have been put in the trunks, terrible things. Anyone that knows anything, please come forward.
Also,
and then there's the whole thing about the hinky meter. The defendant, there was a blog website that the defendant became aware of, and the police became aware of, called the hinky meter. And the testimony shows that on the hinky meter, people were putting out evidence as it related to the defendant and Rachel Gillette. The defendant contacted Therese Giffen, who was one of his acquaintances through the BDSM lifestyle, and he specifically asked her, and the thing that's interesting about Therese Giffen is an ex-police officer. He's having conversations with an ex-police officer, and she knows, as an ex-police officer, when police are given leads, they have to follow. And she said one of the reasons why they discussed putting out the story about Jane having a boyfriend and the boyfriend doing it because it would lead the police in a direction away from the defendant. That is a false statement that shows consciousness of guilt, and you can take it as circumstantial evidence of guilt. And the other thing is, you just don't have to take Therese Giffen's word when she says she put false stuff out. Eileen Stradilat is a friend of the defendant, and the defendant told her that he had 4 people post things on the hinky meter that were deleted. So the defendant, again, is putting out falsehoods in this case. There are certain things that the defendant did that you just don't do as an innocent man. He changed his cell phone usage. Before Jane's body is even found, and before anybody even knew she was murdered, he starts using Nancy Bashara's phone. He used Nancy Bashara's phone to call Rachel that night. He used Nancy Bashara's phone to text Janet Lehman, the lady in Oregon, and say, family emergency, cease communication. The defendant began to hide his motive before there was even a crime to be investigated. When he talked to Police Officer Hayes, he said no extramarital affairs. There's no reason to lie at that point. No reason whatsoever for him to lie to the first person on the scene about his wife's death. At the death notification, he doesn't tell about the extramarital affairs. And even more importantly, on 125, the phone records show he had phone contact with Courtney Johns. And Courtney Johns, who was a tenant at Rachel's house on Cadgy, the house the defendant had sold to Rachel after taking the loan from his mom, he told Courtney Johns, tell anybody, tell the police, if they come asking, Rachel and I are just friends. Those false statements, those attempts to have other people give false statements, go to the consciousness of guilt. Now, this is something really important here. The defendant talks to the police. He talks to Detective Olson. And the Detective Olson tells him specifically, we may need to get into your computers. Like that.
I don't have a Facebook account, nothing.
Okay. Do you and the wife have separate computers, or you guys have a joint computer?
We have a joint computer that, by the way, has died on us. I have to have it worked on it. But we have a joint computer that I have the rentals, and we have some like Christmas letters and things like that on. And then she has her laptop that she uses mostly for that.
Okay. So at some point, that might be something I might need to look at.
Okay.
Maybe she was corresponding with emails to somebody. I'm working on another case, about just that. So it's, mention anything.
Yeah.
But, so computers can be helpful or they can't be. I mean, I can't say that one way or the other without maybe taking a look at it.
Yeah, she has a account.
On the 26th, before any tips come in about Rachel, the police tell the defendant, we might need to get into those computers. Those computers may have evidence. And what does the defendant do? The defendant had a long-standing account on alt.com that he and Rachel shared a blog on. And you can see the dates. The first screenshot is from 2010. So he's maintained this account on alt.com since 2010. And on these blogs, and the most recent blog on that was January 20th, 2012, approximately 4 days before the murder, where Rachel is blogging about the defendant going to Oregon to meet Slave J. That's on the computer. They tell the defendant, we want to look at your computer. And they're not even telling the defendant, we want to look at the computer because we're focusing on you. They said, we want to look at the computer because we might want to find something about your wife. And what happens on the 27th? Did you go into the date? On the 27th, after the police have specifically told the defendant that the computers might be helpful in solving your wife's murder, he deletes his account from alt.com. That account has all the evidence of his motive. Why did he do that? That can be taken by you as circumstantial evidence of guilt. Now let's go to the motive. Rachel Gillette. There is no dispute that he was obsessed with Rachel Gillette. He would say anything and do anything to be with Rachel Gillette. Several people have indicated as such. He tells her, my relationship with her is over, no sex, no feeling. Hell, she's not happy and wants to part. So we're working on a plan. And that continued consistently throughout the years. I want you, period. In 2010, he talks about he's ready to make a life-changing event for her. Life-changing event for her. It continues. And he specifically talks about the financial impact him not being with Jane is going to have on his life. As to the income I will be missing, oh well, I'd rather live in a one-room shack or whatever you said and be happy than be rich and not be happy. specifically indicates in 2011 in an email to Rachel, not having her in my house is a huge rock lifted off us. A rock I am lifting now. And the date on that email was in July. They started house hunting in earnest in August and September.
There's been talk and there's been reports. Was there talk of a divorce? Was there talk of, were you separated?
No, not at all. No.
Talk to me a little bit, I know Dave talked to you a bit of the reports about an affair, extramarital affair. Were you having an affair?
No, I was not. I loved my wife. I loved my children. And I would do nothing to hurt them. And I just, she meant everything to me.
So the reports and the other woman by the name of Rachel, you would characterize that as?
She was a good friend. That's it.
While we're talking about this, we're talking about.
Can I have that up just one more time? You notice he said in his email that the need to hide would be over. So in 2011, in July, they are still hiding the relationship. Those are the defendant's words. Remember, there are power in words. He sat down at a computer screen. He thought about what to say. He chose the words. He indicated to Rachel that our time for hiding is coming to an end. He was obsessed with Rachel as evidenced by the PPO. I am very concerned about my safety in and around my home due to the harassment of Bob Bashara. I have told him repeatedly that I want no future relationship with him, and this is after the murder. He's still pursuing her after the murder. He is deliberate enough to drive different vehicles and park at my house. This shows you the defendant's pattern and conduct when he's doing something he's not supposed to do. He is using different cars to avoid being seen. There are several things that the defendant told the men in his BDSM world about Rachel. He told Patrick Webb that he was going to divorce his wife. He loved Rachel. He also told that to Robert Goddard, the person in the corner there. He told Lawrence Wolf not only was he going to divorce his wife, he was going to take Rachel and Janet Lehman into a new house that he was buying on Kensington. And to that, Mr. Wolf said, "Bob, are you nuts?" So he's telling people what his plans are, and he tells Mr. Falsinelli during the week that his wife is being buried to contact Rachel and tell Rachel, maintain the status quo, I still love you. Because basically, this is my wife's funeral and everything. That's an annoyance, because once this is over, we're going to be together. That is circumstantial evidence of guilt through his motive. And there are constant, and even after Jane is dead, there are constant contacts with the defendant trying to get a hold of Rachel. He uses Giffen. He uses Mr. Fick's phone, his maintenance man, to call Rachel at Wayne State University. He uses Falsinelli repeatedly. And even the social worker at the jail gave evidence through way of stipulation of the defendant's stipulation. She knew about the PPO, and despite the PPO being in effect, the defendant asked her to contact Rachel from the jail. The defendant, even a couple of months after the murder, like I said, I don't know why I cannot get her out of my head. Like you said, she's not a beauty queen, but to me, something special. I can't get her out of my head. Giffen tells me at another point, "You're obsessed. Give it a rest." He says, "I am so relaxed." So the defendant not only had an obsession with Rachel, He gave Rachel lots of money. Money, by the way, he did not have to give. You're going to see an exhibit when you go into the exhibit room, Exhibit 522, that outlines the defendant's constant financial problems since 2009. Can I say? These are the payments the defendant gave to Rachel in 2011 alone. Look at that. From the amount he got from United Labs, look how much money he gave Rachel that year. Money he did not have to give because the testimony will show he was always behind in all his payments. He could not afford to have both Rachel and a wife.
Let's stop right here. Stretch break. Let's stand up. Stretch break. You need your glasses. Okay. Let's take a 10-minute recess. Okay. He needs to get his glasses. And we'll be right back. Okay.
Court is back in session.
Let's bring that jury back out, please. I want them to with my deputy. Okay, and I'd like to indicate that during the break, there were a couple people talking in the courtroom. You can't talk in the courtroom, okay? Ready? Yes. Where are the attorneys?
Oh, Mark went to get him.
Wait a minute, one second, the attorneys are wrong.
They're in the lounge.
Thanks, Pat.
Are you ready?
Said they're on their way.
She's right behind me.
Are you ready, Ms. Dion?
Yes.
Okay, great. Okay, on these breaks, we can't go too far, okay? Bring the jury back out.
Please be seated.
All right.
Here, get on ready. Oh. You may proceed now.
Thank you. The defendant's obsession with Rachel did not die when Jane was murdered. It kept going. Almost a year after Jane's murder, more than a year after Jane's murder, he is still obsessed with Rachel.
Anything on scent from cat purr? Check out cat. Casper has moved to Pennsylvania and is writing a book. Want to write a book.
Now, let's talk a little bit about conspiracy. The principal charge in this case, starting off. First charge you're going to have on your information. And essentially, conspiracy is nothing more than the defendant and someone else agreeing to commit a crime. That's all conspiracy is. Let's start off with the evidence of conspiracy. That is a clip from the solicitation to kill Joseph Gentz. And the defendant says, once I pay you money, it's fucking conspiracy again. He chose the words again. There's power in words. The first conspiracy that was entered into was the conspiracy to kill Jane Bashara. This is the second conspiracy that he entered into, and he indicated again. And who is he making this statement to? He is making this statement to Steve Tabato, the person who hooked him up with Joseph Gentz. Now, there's a certain way you can view this evidence. The law says that if the defendant threatened and or solicited someone to have Joseph Gentz, and right now we're focusing on Joseph Gentz killed, that such a threat and the solicitation, if made, may be considered by you as circumstantial evidence of guilt. You have to determine whether a threat or solicitation was made, and you really don't have to determine that because the defendant has already pled guilty to that. And you may use this in your determination, the guilt of the defendant on these charges. That, in and of itself, the fact that he attempted to have Joseph Gentz killed is circumstantial evidence of his guilt on the charge against Jane Bashara. That is the law. You can take the fact he tried to kill Gentz, and really, what reason other than shutting him up does he have for killing Gentz? Now, somebody may say, oh, well, he was, he wanted to avenge the death of his wife. He's not thinking about Jane Bashara. Once Jane Bashara was out of the way, the only thing he's thinking about is Rachel. But he has to get Gentz out of the way to get away with crime. And that's precisely what he did when he went to Steve Tabato to try to kill Gentz. What other evidence do we have that there was a conspiracy and the defendant was a part of it? On 2/29, Steve Tabato gave a statement to the police. On 3/1, the defendant shows up at Steve's furniture, banging on the back door and says, I hope Steve doesn't throw me under the bus. And let's talk about that for a minute. What does Steve have to throw him under the bus about? At this point, there's two things that Steve could tell the police, and two things that Steve did tell the police. A, that earlier, around late summer, early fall, the defendant came to me and he asked me, did I know somebody who could set up a hit and run? And the second thing he could tell the police, and what he did tell the police, is I introduced the defendant to Joseph Gentz. But the defendant, Mr. Bashara, says, I hope Steve doesn't throw me under the bus. Those are the two things, those are the only two things that Mr. Tabato could tell the police. And he doesn't want Steve to throw him under the bus because he knows when the police hear those two things, A, I introduced you to Gentz, and B, earlier you were looking for somebody to do a hit and run on somebody, it's all over. A guilty conscience needs no accusing. That is, again, circumstantial evidence of the conspiracy.
I did not. The door that Eddie turned around and he says, yeah, Bob says you're throwing him underneath the bus.
No, bullshit. Bullshit. I never said that. All I said to him is, so many people are throwing me under the bus.
Oh, so many people are throwing you under the bus.
Yeah, not you. Yeah, not you. No, look, I don't know what you're doing.
That that call is a perfect illustration how defendant, when he's confronted with something, he tries to spin it to an innocent meaning. Steve Tabato said, you came in here saying, I'm throwing you under the bus. And the defendant, when he's confronted with that, tried to turn around. Oh, no, I didn't say that. I said other people. And you have seen how the defendant consistently lies in this case. Mr. Promoty said, I pretty much came to the conclusion when the defendant's mouth was open, he was lying. That is circumstantial evidence of the conspiracy. And when he said, I did it again, that's direct evidence of conspiracy. What else do we have to support the defendant, in fact, was setting up a conspiracy? We know that the defendant, through all the evidence in this case, when he wants something done, he tries to get it done by multiple people until he can find the person who does it. He went to Steve Tabato and asked him, did he know somebody could do a hit and run on a tenant? But he went to one of his BDSM friends, Mr. Gallard, earlier in the year 2011 and asked him, did he know somebody could rough up a tenant? So you have evidence from other sources, multiple sources, that in 2011, after he told Rachel he was lifting the rock off him, that he's searching for somebody to do violence. Now we have the testimony that came in by way of a transcript of Gregory Baracco. Gintz asked Baracco to help to hurt a lady in Grosse Pointe. He said he's going to be paid about $5,000. He planned to do a hit and run with a big car and bring it for a Bob guy. That is evidence of conspiracy. And that mirrors what Steve Tabato said the defendant was looking for earlier, a hit and run. And we know Steve Tabato is a truth teller because the defendant pled guilty based on the charges that Steve Tabato told us about. Additionally, we have the testimony of Mr. Magona. That in November 2011, Gintz talks about Patty, money, and Bob. And Gintz has a conversation on the phone that he overhears, and he said this guy wants to do a hit and run on his wife, and he wants her knocked off, and it was an insurance job. We know from Steve Tabato that the defendant was looking for somebody to do a hit and run. How would Magona know that unless Gintz told him? They are all working to get this conspiracy done. Now, I want to talk to you a little bit about two people in this case who are very similar, Joseph Gintz and Thomas Ramsey. And when you look at defendants, compare how the defendant treated each person, that is also evidence of a conspiracy. Rebecca Fortin indicated that when the defendant brought Joseph Gintz to rent the house on Wayburn, when she was concerned about him not having enough income, the defendant said, oh, he's a great handyman, he can do work for you. Kim Tower indicated that the defendant recommended Thomas Ramsey to do work for him as a plumber. The defendant knew the Gintz for a long time. That's what the defendant told Ms. Fortin. I know the defendant for a long time. He'll be a great tenant. I'm vouching for him. But he didn't know him for a long time. He only knew him for a period of weeks. He told Kim Tower, I know Tom Ramsey for a long time. He's going to be a good plumber for you. The defendant said all types of good things about him, both of them. And you will look at the exhibit from Stanbrew, exhibit number 23. You will find that there's substantial phone contact to both the defendant, between the defendant and Gintz, and the defendant and Tom Ramsey. What happens next? The defendant uses Gintz to kill Bashara, Jane Bashara. The defendant uses Tom Ramsey to keep him informed about what's going on at the apartment complex when the police are coming out there. He also used Thomas Ramsey to intimidate Mr. Schatz. There was testimony from Mr. Schatz that Thomas Ramsey and the defendant came into the laundry room, blocked them in, and Thomas Ramsey was saying, don't say anything bad about Mr. Bashar, things of that nature. Thomas Ramsey Mr. Schatz indicated he was scared by that. So the defendant is using both people basically is muscle. That's his pattern. And then what happens? Both people end up being potential witnesses against the defendant. Joseph Gentz was a potential witness, and he was waiting his competency hearing, and the defendant was afraid that Gentz was going to cut a deal against him. What about Ramsey? Let's hear about Ramsey.
Did Thomas have anything to do with that?
Yeah, he was involved in that, hell yes. But he didn't come forward because we didn't go to trial.
So he indicates that Thomas Ramsey was a witness in the solicitation case. He's telling that to Ralph Lee on the phone. So we got both people, after they've done something to the defendant, now they're becoming potential witnesses, and then what happens? He attempts to kill their credibility first. Gets he's a retard. He's fruitier than a loon. He's crazy. He came looking for money. What does he say about Ramsey? He's selling prescription drugs at the complex. He's causing all kinds of disturbances at the complex. So first, when a person begins to be a potential witness against the defendant, he starts to attack their credibility.
Okay, now who's Thomas Ramsey? Just say the 210. They'll know what Thomas and 210. They'll know who that is. I need them to write up everything they know about him, his personality, his use of dispensing drugs, prescription drugs like Oxycontin and stuff to those guys. Specifically Bob when he had a bad back. She gave him all sorts of stuff. So I need, and his behavioral history over the last year.
So you have a situation.
Just give.
Excuse me. So you have a situation for the defendant when a person's useful to him, when they're doing his bidding, when he's in control, everything's good. It's all good. But the minute the person says anything against Mr. Bashara, he goes on the attack, tries to destroy their credibility, and when he can't destroy their credibility, he attempts to silence them. We have the guilty plea where the defendant pled guilty for attempting to kill Gentz, and then what happens to Thomas Ramsey? He ordered an eviction on Thomas Ramsey once Thomas Ramsey started to participate and cooperate with the prosecution. What's that called?
Okay, now who's Thomas Ramsey? Just say the 210. They'll know what Thomas and 210. They'll know who that is. I need them to write up everything they know about him, his personality, his use of dispensing drugs, prescription drugs like Oxycontin and stuff to those guys. Specifically Bob when he had a bad back. She gave.
And ultimately, through the testimony of Ellington, which we'll talk about at length later, the act wants to have a hit done on Thomas Ramsey. The defendant has a pattern of using people, and when they say something against him, he wants to attack their credibility. This is a letter that the defendant wrote to his friend, Mr. Falcinelli. Go back for a minute. Specifically, he's talking about Patrick Webb, who was a witness in this case. Patrick Webb came in here and indicated the defendant said at one point that when they talked about divorce, getting the divorce would be, he said it would be cheaper to kill the bitch or something along those lines. But we know previously he was in good with with Mr. Webb. He was also often trying to get Mr. Webb some money to build the BDSM facility, but now that Thomas Webb is a witness against him, what does he do? And other people from the lifestyle. He wants Mr. Falcinelli to begin digging up dirt on them, because when they're useful to the defendant, you're okay. But the minute you're no longer useful to the defendant, he discards you. But let's look at some more concrete evidence of the conspiracy and the conspiracy that was taking place in January. On January 21st, the defendant calls Gentz 2 times, and Gentz calls the defendant 1 time. The 22nd, the defendant calls Gentz 4 times. And notice, the Gentz is not really responding back to the phone call. On the 23rd, he calls Gintz 22 times. First call in the morning when he wakes up, last call at night, he calls to Gintz. And the evidence will show, or has shown, I believe, Stan, who testified that after he called Gintz on the 23rd, he called Rachel, the two most important people to him on the day before his wife was murdered. And on the 24th, defendant calls Gintz 5 times. Gintz called the defendant twice. Now, let's look at the phone patterns with Gintz in relationship to other things that were going on with the defendant in January. On January 20th, the defendant gets the email from Rachel, and you're going to get a calendar as an exhibit. Ask for it. It has all the exhibits and the dates that things correspond to. On January 20th, Rachel gives him an ultimatum. Give me the divorce papers or I'm out of here. On the 23rd, the defendant picks up the closing packet. On the Sunday before the murder, Mr. McQueen indicates that he witnesses a hot and heavy argument between the defendant and his wife. And on the 27th, you have the date of the closing. All these things are taking place in the same context of these phone calls to Gintz. On the 25th, the body is found, and there is a 1 minute, in excess of 1 minute call between the defendant and Gintz. And then on the very next day, there is the payment to Gintz.
How many times did you say you texted in the last 3 weeks?
A couple, just because he texted me, call me, do this, and I just said, leave me alone. I really called him back. When he texted me, I would call him back and say, please don't bother me. I'm not giving you any more work. We're done. And I paid him the $452 from a business checking account. And we were done.
And the $450 was for what, Bob?
For work that he did, these menial tasks in December and January.
So 3 weeks, in the last 3 weeks, you maybe talked to him, you said more than a dozen times.
He's mostly called me, correct.
That is another false statement the defendant is making about his connection to Gintz. He said Gintz mostly called him in the last 3 weeks. That's not true. Why is the defendant lying about that? And once again, that false statement can be taken by you as circumstantial evidence of guilt. He uses Nancy's phone on the 26th to contact Gintz, and then he immediately goes out and pays him. And you have evidence of the payment. Now, before I get into the next witness, I want to talk to you a little bit about the concept of corroboration and credibility. In our society, there are certain people who have automatic credibility. And no matter what they say, or no matter what they do, either by the accident of birth, zip code, money, status, they have automatic credibility. Mr. Bashara is one of those people. By virtue of the fact that he was a Rose Pointer, the Rotary president, and father was a judge, just those facts alone gave him credibility. And you contrast that with somebody like Paul Monroe, convict, drug dealer. He has automatic, no credibility. But then you have to ask yourself, how did these two people, a person of the highest credibility in our society and a person of our lowest credibility, get together? But when you evaluate the testimony of Paul Monroe, you look at it in terms of whether his testimony was corroborated. And his testimony was corroborated. He indicated that the defendant met with him sometime in June. They were in a car near his house, and the defendant indicated that Gintz did it. He had Gintz to do it, and doing it, he did it because the divorce was like losing money. What do we have to support that? The The phone records show constant contact between the defendant and Monroe between April and June of 2012. There's 28 phone calls to the investigator for the defendant. And on 6/20, right smack dab in the middle of the defendant doing the solicitation with Gintz, solicitation to kill Gintz with Mr. Fato, he's meeting with Monroe, and he's stressed, and the phone records show that the phone towers have the defendant in the home phone towers of Mr. Monroe. Now, Mr. Monroe said the defendant met with him several occasions to do cocaine. Now, and I know if we had not brought Jim Wilson in here to talk about the defendant's cocaine habit, people would say, oh, no, not Mr. Bashara. He wouldn't be doing cocaine. Those are the two things they have in common. The defendant tells Stephanie Samuel, his cousin, all about Paul Monroe. He tells her that Paul Monroe has information about April Montgomery, and the defendant wanted to use Paul Monroe for his own purposes. He tells his cousin, Stephanie Samuel, that Paul Monroe has a new suspect for them. That corroborates what Paul Monroe said, that the defendant wanted him to come forward with this information about April Montgomery and her boyfriend. The defendant felt comfortable with Paul Monroe. Now let me just talk to you a little bit about the defendant and what he says about Paul Monroe and people that he has a relationship with. There is a call. I'm going to jump ahead just a little bit. There is a call where the defendant is talking to a book author. And he's talking to the book author about having contact with 3 convicts through his rental business. And the investigation has revealed those 3 convicts: Ralph Lee, Thomas Ramsey, and you'll see that in the stipulation, and Paul Monroe. And the defendant says that he develops a comfort level with these people, and they work out well for him. So let's hear that before I go any further and we can backtrack.
Let me tell you, I hired 3, or not hired, but I rented to 3 convicts, previous cons. All 3 of them worked out great for me. They were, one of them has got money on his phone, and I still talk to on a regular basis today. Sent me $40, stuff like that. Because I gave him the chance to make a life for himself. And I gave him some odd jobs and did things, and he was, but I didn't just jump into it, and so you develop a comfort level with people. And that's what I did with these other guys. And
he's talking about the 3 convicts: Paul Monroe, Ralph Lee, Thomas Ramsey. He said he built up a comfort level with those people. He trusted them. And that is why, while he was doing cocaine with Monroe, he started crying. And he said he had Gintz kill his wife. And he said he had to do it because it was like losing money. Monroe indicated that the defendant looked stressed, strange, crazy, his eyes bugged out. That is consistent with what Mr. Travato said. Mr. Travato said that the defendant looked like a zombie.
You look like you got some medication or you're coming down. The other day you looked like you hadn't showered and shit for a week. Oh, bullshit. I looked all right. What are you talking about? You look terrible. Okay. You look like you were a walking fucking zombie.
Now, the testimony about Paul Monroe is corroborated in part by the testimony of Jim Wilson, because Jim Wilson indicated the defendant had a cocaine issue, and Jim Wilson indicated that when they were out on the golf course, the defendant would confide in him while they were doing drugs together, drugs and drinking. That fits with the defendant's pattern of being comfortable with people that he's doing drugs with and talking about things that he might not normally tell people in his Grosse Pointe world. There's also testimony from Mr. Ellington that the defendant said he had to get rid of Gents because that fucking retard killed his wife. He indicated that he had to do it because, he indicated he had to do it because Gents was the only witness against him. Now, what do we have in terms of supporting the credibility of Mr. Ellington? First of all, there's payment to Ellington.
Because I don't play that. I know the first one you mentioned. I want you to take care of that.
Well, I don't have the person's number.
I know. You'll get it. You'll get it.
Yeah.
Okay.
Some guy named Larry.
Anyways,
in addition to the payment to Ellington that was made, there was a call that you heard during the course of this trial when the defendant asked Richard Falcinelli to send a secure pack to Ellington, but he didn't want Falcinelli to put his name on it because it couldn't be traced back to the defendant. Why is he sending a secure pack to Larry Ellington? Why is he instructing that his name not be on that secure pack? That is evidence that he is doing something nefarious. Then we have the situation where Mr. Ellington indicates that there was an ill-defined plan about this hit on Gents. But the payment for this hit on Gents was going to be the house on Guilford and some money being put on his account every month. And he has Rick's phone number, the defendant's power of attorney. Now, can I have that call? There is discussion between the defendant and Larry Ellington about doing a hit on Tabata, Ramsey, and Gents. And that discussion went on for several days. And at some point, right before the preliminary examination, it became obvious that Larry Ellington had told this information to the police, and Mr. Falcinelli and the defendant had a phone call about that.
He told me about what your little friend from up north did. Who's not doing us any favors, a little two-faced son of a bitch.
Now, at that point in time, he said that little two-faced son of a bitch. Mr. Falcinelli has information from the attorneys that Ellington is going to testify about the plan. Now, what are the similarities between the situation with Ellington and the situation with Tabata? And these are things, there are certain things that there's no way that Mr. Ellington would know. The defendant is paranoid. Tabata says that Mr. Defendant thinks he's wearing a wire. He checks the defendant's phone for Matuk's number. So when the defendant is cutting the deal to kill Gents with Mr. Tabata, he's paranoid. When he's doing the same thing with Ellington he is paranoid. He indicates he thinks the cell is bugged. He flushes the notes down the toilet. And the defendant's paranoia has been corroborated by yet another witness, Ralph Lee. Ralph Lee indicated early in February the defendant said his phone was bugged. So Mr. Ellington is telling you things about the defendant that's been corroborated by other testimony. He said the defendant was paranoid. With Ellington and Ellington and Tabata, the defendant used disparaging terms about Gents, Ramsey, Tabata. And in both cases, there was a payment and really an ill-defined plan. Now, if there was not a tape recording of Tabata setting up the hit with the defendant on Gents, nobody would have believed it because there was no plan. It was just crazy. We're going to get him, he's at Dickerson, all that kind of thing. Didn't make sense. There was an ill-defined plan with Ellington. But what's important here is the defendant, when he gets desperate, does stupid stuff. He does crazy stuff. The desperation in the defendant was evident in June. Can I have that June calendar?
Let's stand up and take a straight. You may be seated.
solicitations. First of all, Gentz is found competent on the 11th. The next thing that happens is James Wilson is giving testimony under oath. Then we have all that information on the 18th, 19th, 20th, 22nd. That's when the solicitation is going on hot and heavy. And what you have to understand about the solicitation to kill, the defendant was exceedingly desperate because he had several opportunities to walk away. The 18th, the 19th, the 20th, after he talks to Paul Monroe, on the 22nd, he has the 23rd and the 24th to walk away. He's desperate to get it done, and then he does that crazy, ill-defined plan where he gives Tabata money with no really how is it going to get done. But that speaks to the defendant's desperation. When he is desperate, he just does stuff. And let's focus that whole desperation and how he does something stupid out of desperation from January. In January, we talked about the things that were going on in January. The house closing, the email, I'm going to, if you don't give me your divorce papers, I'm going to get rid of you. Closing packet on the 23rd. So everything is closing in on the defendant both in June of 2012 and January of 2012. And there's something else that tells you about the credibility of Mr. Ellington. There's something that the defendant knew about Thomas Ramsey that he told Ellington that was never made public anywhere. He gave the defendant Thomas Ramsey's address. He told the defendant told Ellington that Timothy Ramsey lives on 3 Mile Island. That had never been in any paper, had never been anywhere. The only way that Ellington could have knew that Thomas Ramsey, he called him Timothy Ramsey, lived on 3 Mile Island is for the defendant to have told him that. So let's look at the elements of conspiracy and let's say how the evidence is applied to elements. The defendant and someone else knowingly agreed to commit first-degree murder. That has been supported by both direct and circumstantial evidence through Ellington, Tabata, Ramsey, the actions he took against Ramsey, that the defendant specifically intended to commit the crime of first-degree murder, or help someone commit the crime, or arrange the commission of the crime. And the agreement took place from October 2011 to January 2012, and the dates for that are essentially from the date he met Gentz and started helping Gentz until the day payments were made and acted on the 29th. Solicitation. For solicitation, all I have to show through the elements is that through words or actions, the defendant offered, promised, or gave money, services, or anything of value to Gentz. Well, let's look at what he did for Joseph Gentz. Joseph Gentz had a daughter in foster care. There is evidence that the defendant indicated that he was going to help him with that. He needed a place to stay. He helped him with that. Joseph Gentz, through all the evidence, is slow. Rebecca Ford indicated that she knows special needs people. She worked with special needs people. And Gentz presented like somebody with a closed head injury. The defendant, through his own words, indicates Gentz is slow because he calls him a retard. The defense had minimal income in 2011. The rental agreement indicates that his income was roughly $1,000 a month. But look what the defendant's state of mind is, what Gentz's state of mind is shortly after meeting the defendant. Shortly after meeting the defendant, he begins emailing or texting. I'm going to move out of this apartment and move into a richer neighborhood. I'm real rich. I am moving to Grosse Pointe. I'm from St. Clair Shores to Grosse Pointe. I am with an upper-class neighbor, really rich class. Then you have the state of mind text about the Cadillac. get that Cadillac from your buddy? No, did not get it, but I am working on it. Is he really giving it to you? Yes. Am I going to get the car? No, I'm in a very nice place. Then he goes on, at the end, I'm messing around with these rich people. Then you have the defendant actively helping him get that apartment. You have the defendant putting utilities in his name, the defendant's name, and that's another thing. The defendant, with all his financial problems, the defendant can't even pay his own bills on time. Why is he assuming the financial obligation for Joseph Gintz, a man he has just met? That does not make sense. Before the defendant met Gintz, before Gintz met the defendant, he never had any money. Gintz indicated that he was expecting a package in January 2012, and the package came in. The defendant delivered the actual payment to the defendant on the 26th. Now, the Cadillac. Let's talk about the Cadillac. There is a lot of talk about the defendant promising the Cadillac to Joseph Gintz in return for the hit. Gintz told several people about that. And what's important about Gintz telling people about the Cadillac, he told the people about the Cadillac pre-murder. Now, the defendant said, well, they're just making up this story on me to get a plea deal for Gintz. But Gintz had been saying even before the murder that the defendant promised him the Cadillac. And then the defendant's false statements about the Cadillac and the timing of his statements about the Cadillac to people corroborate that there was a conversation with Gintz about the Cadillac. He told Carmody, and this is only after the evidence came out in the media, that Joe was supposed to be working for the Cadillac. He never mentioned to Stephanie Samuel about the Cadillac story until Gintz said it first. And he told Jessica the story much, much later. And what do you know about the defendant and that Cadillac? He offers that Cadillac to people when he wants them to do something for him. He offered that very same Cadillac to Therese Giffen when he was asking her to harass Rachel, and he said, let's hear what he said.
I'll give you that Cadillac. I got an 81 Cadillac. I'll give you free and clear. Runs like a champ.
Now he said the Cadillac runs like a champ, and you heard from Shaq and everybody at the Cotton Complex the Cadillac didn't run, but this is once again evidence that the defendant will say anything and do anything when he wants someone to do his bidding. But most importantly, and I think this is very significant in terms of what the defendant offered to Joseph Gintz to show a solicitation, is there's this evidence about a ring. Jane Bashara had a very expensive wedding ring. That wedding ring went missing right before the murder. She left a note for the cleaning lady. I've lost my wedding ring. Please keep your eyes open for it. That note was found in the trash by Roxanne Flasco, the day her body was found. But let's look at Joseph Gintz's text messages at around midnight on the 21st. On the 25th. I love you, Babby. Can I see you this weekend? And I will give you something to wear. Spelled wrong. I need your size of ring. It is more than a cosmic coincidence that Jane Bashara's expensive wedding ring goes missing right before she gets killed, and at midnight, right after midnight, on the 25th, Joseph Gintz is talking to somebody about getting size for a ring. But then, guess what? The defendant finds the ring on the 27th. So for solicitation, all the people have to show beyond a reasonable doubt is through words or actions the defendant offered, promised, or gave money, services, or anything of value to Joseph Gintz. And that when he did that, he intended that to cajole Joseph Gintz into killing his wife. Now let's talk about the elements of first-degree murder. I would like to start with what the defendant told Patrick Webb. The defendant said he was trapped in a marriage, and sometimes I think it would be cheaper to kill the bitch. Now let's look at murder in the context of the law of aiding and abetting. The law is that anyone who intentionally assists a person of committing a crime is as guilty as the person who directly commits it. And for aiding and abetting a first-degree murder, all I have to show is that before, I'm going to emphasize that again, that before or during the crime, the defendant did something to give his assistance. And it does not matter how much aid, assistance, or help the defendant gave, just as long as that did, in fact, induce the crime. Now, in this case, the guilt of the defendant can be based solely on the conduct that occurred pre-murder. Let me say that again. The guilt of the defendant can be based solely on the conduct that occurred pre-murder. And in this case, entering into the conspiracy and entering into the solicitation is the pre-murder conduct that establishes guilt. As it relates to that, in order for the murder to occur, there had to be preparation. In order for the murder to occur, the defendant was not going to do it himself. He had to find somebody to do it for him. The pre-murder conduct is the solicitation of gifts, him soliciting Tabata, him looking to Mr. Goddard to try to find somebody to do that. That is pre-offense conduct that can be used as guilt. Now, there is no dispute whatsoever that in January 2012, Joseph Gintz killed Jane Bashara. There was repeated blunt force trauma to her body, and there was such force applied to her trachea that it fractured it. The defendant, Mr. Gintz, indicated that Jane was on the floor of the garage. She was laying there. Her neck was broken, and she was strangled. Her neck, the trachea was broken, and she was strangled. He indicated that he thought they were going to have DNA on him. But more importantly, what Joseph Gintz said to Mr. Vergona, that's in Mr. Vergona's statement from the 31st, Joseph Gintz said he thought that he was going to be the next person killed. Joseph Gintz knew the defendant, and he knew that he was going to be killed. How could Joseph Gintz know that unless that actually occurred and the defendant actually told him that? Now, absent the defendant, there is no reason for Joseph Gintz to kill Jane. What earthly reason did Joseph Gintz have to kill Jane? He doesn't have a motive to kill Jane. The only person with the motive is the defendant. The only connection, and in terms of Joseph Gintz killing Jane, why was no property taken? There's no signs of forced entry at the house on Middlesex. There's no disturbance at the house on Middlesex. And if Joseph Gintz was coming after the defendant looking for money, why is no money taken? Why are no valuables taken? Joseph Gintz is just going to kill Jane Bashara for no reason, not take property, not take money, not take anything. And there's no reason for Joseph Gintz to move the body. Why would Joseph Gintz have to move the body from Middlesex? Why would Joseph Gintz have to stage a crime scene? That does not make sense. Now, the judge is going to give you an instruction about how you can view certain evidence. She's going to give you an instruction about the defendant and the attempt on killing Gintz. And she's going to say that you can use that as evidence that the defendant used this as his Now, in order to find the defendant guilty of first-degree murder, you have to find that the defendant incited, cajoled, or encouraged Joseph Gentz to do the physical acts that killed James. When you put everything in together and in context, the payment to Joseph Gentz, the constant attention to Joseph Gentz, he's very solicitous of Joseph Gentz. You're going to see a text message when you get in. Joe Gentz asked him in late December, Bob, I don't have any food in the house. I don't have any money. Can you loan me $50? Defendant texts him back in less than a minute. I'll call you. He's very solicited of Joseph Gentz for no reason. Now, the defendant might say, well, I was trying to help Joseph Gentz out. But if he was really trying to help Joseph Gentz out, he has all his Rotary ties. Rotary does all this fundraising work. Rotary has all this charity work. How come he's not even getting those people involved in helping out Joseph Gentz? The only connection that Joseph Gentz has to Jane Bashara is through the defendant. There's no other reasonable explanation for the killing. Now, the intent to kill can be shown by the fact the defendant sought out multiple people. He indicated getting a divorce was like losing money. He said he was trapped in a marriage that was people to kill the bitch. And more importantly, he told 3 separate people that would be his last Christmas with Jane at Middlesex. He told Young, he told Lehman, and he told Rachel. And then, that was his last Christmas in Middlesex. Furthermore, the defendant's story about the alibi just doesn't make sense. He makes a point to have people notice him. He goes to great trouble to create this alibi, and it doesn't make sense. It is the middle of winter, cold, outside, and he's sweeping in the alley for hours, in the dark, by the way, because sunset was at 5, so he's sweeping in the dark, and it's not even his responsibility to do that. Now, there's other evidence that indicates that the defendant was actively involved with Joseph Gentz. It's the issue of Jane's phone moving. What we have is her last call was at 1:24. It was an outgoing call. 1:24. It was an outgoing call, and she was on her home sector at 9:94. That call was at 16:40. The defendant is on the phone at this time. She's actually calling the defendant. He's on the phone with Rachel at this point in time, but he says in his statement to the police that his hands were full because he was working. Jane's phone uses the Grosse Pointe home towers from 4:40 to 6:28 on the day of the murder. The defendant's phone uses the Grosse Pointe home tower at 6:26 on 1:24. So within 2 minutes of each other, both the defendant and Jane's phone were using the Middlesex home tower. The next call on Jane's phone, she's using another tower. And this is the first time that tower is ever used in her records, and that's at 6:43. And finally, at 9:28, her phone is using the tower of the discovery site. Now, what do we know about all this evidence? Jane was dead by 6:20. Jane was dead by 6:43, and at Annette at 6:47. And the reason why we know she was at Annette at least 6:47 is because Joseph Gentz was in the McDonald's at 7:47. Excuse me, at 6:47. Defendant's phone used the home tower at 6:26. Jane's phone used the home tower at 6:28. And both the next call for both the defendant's phone and Jane's phone are using phone towers other than the home tower. Now, the court will also instruct you of for first-degree murder. The defendant aided and abetted the cause of death of Jane Bashara. The defendant before or during the crime did aid, bet, assist, help cajole or incite Joseph Gentz with intent to kill Jane Bashara. The intent to kill was premeditated. The killing was deliberate. And all premeditated means is the killing was thought out beforehand. The judge is also going to instruct you on the lesser included case of second-degree murder. Charge, thank you. A second-degree murder. And second, they both share the first element. The defendant aided and abetted the cause of death of Jane Bashara. That is, Jane Bashara died of strangulation, and the defendant had one of these three states of mind: the intent to kill, or the intent to do great bodily harm, or the defendant intended to do an act that was in wanton and willful disregard of the likely consequences of his act. That's it. Now, the defendant is also charged with obstruction of justice. And as it relates to the obstruction of justice charges, did the defendant do something that prevented witnesses from cooperating with the prosecution? And first and foremost, 3 witnesses, based on their actions with the defendant, had to get immunity to testify. His mother, his cousin, and Ms. Giffen. Based on what they did for the defendant, that obstructed them coming in to testify without an immunity agreement.
I'm not a violent man. I'm a pacifist, actually. I don't own a gun. I am not violent. I stopped playing football because I didn't like hitting people. I loved my wife dearly. Loved my wife. The mother of my children. I would never harm a hair on her head.
Now, what's significant about the gun and the hiding of the gun is the defendant knew Joseph Gentz had indicated that he did it at gunpoint. He did it because he was forced to do it by the defendant. And the defendant went on the offensive and told everybody that he didn't have a gun. Yet he used his mother and Stephanie unwittingly to hide that gun in the safe deposit box to keep it from prosecution. There are several witnesses the defendant had interfered with and obstructed in this case. Let's start with the first. The defendant did arrange to have a witness, or attempt to arrange to have a witness hidden out of state. Janet Lehman indicated the defendant called her sometime in February and asked her to use her credit card to pay for a plane ticket to get Rachel out of state. Rachel was a witness, obviously, in this case. And he indicated to Janet Lehman that he wanted Rachel hidden from the court. Or, now, for the obstruction of justice, we don't have to prove all of this. We just have to prove any one of these. He asked Lehman to lie. He asked Giffen to lie. He asked Fick to lie. And he also asked Courtney Johns to lie and say that the relationship with Rachel was just platonic, that they were just friends, things of that nature. He engaged agents to evict someone. Let me just go to that one real quick. Thomas Ramsey. You have heard from your own ears the phone calls where the defendant indicated he wanted Thomas Ramsey evicted, and that was right after he was arrested for the solicitation. He wanted Thomas Ramsey evicted because he knew that Thomas Ramsey was a witness against him in the solicitation case. He engaged his mom and Stephanie to hide evidence, which is the gun. We talked about that. And he engaged Giffen to put out false information, and he also engaged Giffen to repeatedly contact Rachel and harass her. You remember the phone calls where he told her, it was a phone call actually, where he told her to go after her with both barrels and to give her a blistering email. All those actions amount to obstruction of justice. The last charge I'm going to talk to you about really briefly is the witness intimidation. And for witness intimidation, you have to show, the witness intimidation goes to Rachel Gillette. The defendant repeatedly contacted her, and she indicated that this contact was making, she felt intimidated by him, she was threatened and frightened. That continued through Therese Giffen. Therese Giffen, he was giving her specific instructions to contact Rachel, to harassed Rachel, to give Rachel both barrels, to send her a blistering email, and Giffen did in fact contact her sometimes, and sometimes she didn't. But she indicated she did that at the direction of the defendant. Now, as it relates to this case focuses primarily on the conduct and the actions of the defendant, what he did and who he did these things with. He contacted Joseph Gentz. He courted Joseph Gentz. You will see the phone records about how much contact he had with Joseph Gentz, and ultimately he got Joseph Gentz to do what he wanted through promises of a car, through promises of money, through promises of a richer lifestyle, through promises of a ring. So essentially, the case starts with the defendant's words, and they're going to end with the defendant's words. Proverbs 18:21. Death and life are in the power of the tongue. What were the defendant's words as it relates to this? He indicated first that he was a widower. When he first met Rachel, he set up his profile. He set up a profile indicating that his wife was dead. Then he tells people it's cheaper to kill the bitch. Getting a divorce is like losing money. He says the last Christmas with Jane at Middlesex he was spending, this was 2011, that was it. He said, not having her in my house is a huge rock, a rock I am lifting now. These are all the defendant's expression of his intent as it related to his wife. Those were his words. But we also have the words of Jane Bashara, and the words of Jane Bashara in her state of mind, how she felt. She indicated they fought. She indicated she can't trust what he says. More importantly, on the financial front, there was a trust she made, and in the trust she made, she indicated that under no circumstances would the defendant ever control the money on that trust by himself. This case relates to the defendant's finances. This case relates to the defendant's need to be away from his wife and his need to be with Rachel. Words do matter. Words were important. Words were important to Jane Bashara. The words, till death do us part, meant one thing to Jane Bashara, but they meant quite another to the defendant. Thank you.
Thank you so much. At this time, we are going to break for lunch. I'm going to see if we can get the, I need to extend the band time because I want to get everything done today. But I need to still be able to give you breaks. I need to be able to let you have an ample lunch because tomorrow you're going to be getting the instructions and you're going to be getting the law and you're going to have to think about what the evidence you saw with the prosecution and the defense all see, and you're going to have to come up and try to make a decision to determine whether or not the people have met each and every element beyond a reasonable doubt. So it's not to delay. It's just to give you an opportunity to take breaks because you need a mental one. Okay? Very good? Okay. So, Judge Evans, when will we see you back? Let me see if I can work some magic. Let's say I'll see you back here at 12. It's 12:08? That's right.
Get up.
I'll see you back at 1:30. All rise, all rise. Let me know when you're ready to go as a group.
Yep, she said 1:30. Ooh, it's cold all of a sudden.
It's gone from heat, cold.
what we're gonna do, once they leave out, is start set up. Oh, yeah. I forgot about that.
Excuse me, guys. Are you using our stuff?
No, he's got his.
Okay, all right.
own stuff. I think we're good. We just gotta hook up.
We need probably the cord, the GPA.
Tell us what you need.
Huh?
Tell us what you need.
Yeah, because that's probably gonna be longer, so it seemed to work well.
You need the stand as well, correct?
Oh, no.
Will you do that for me? Print it. Oh, that was low. Sorry.
Too late.
Okay.
That's great. You get through here?
Oh,